Hello everyone. I welcome you all to the theme Vidivani, which means voice of law. Under this theme, we will be discussing on various questions of law and judgments, which I personally feel is important for a professional, especially company secretaries practicing or working in corporate law to know. Without wasting any time further, I would like to place today's question of law for discussion here. That is whether selective reduction of capital under the Companies Act 2013 is possible or not. Or in other words, whether reduction of capital by the company can be done by extinguishing or cancelling the shareholding of the particular class of shareholder is possible or not. Why this particular question of law has been placed here for discussion today is because recently I was reading one of the judgment wherein the applicant has moved against the scheme of reduction of capital introduced by the company, and the brief facts of that particular case is that the company has provided the exit opportunity via route of reduction of capital to a particular identified group of shareholders, that is minority shareholders. So the contention in that case is broadly on two grounds. First, that the selective reduction of capital is not possible. Second, the valuation which has been provided in the scheme is unfair, unreasonable, and therefore the scheme is not tenable. So it is very important for us to know whether such transaction is possible under section 66 of the Companies Act 2013 or not. Starting with the provisions of section 66, the first line itself creates a doubt in my mind. It says that a company limited by shares or a company limited by guarantee and having share capital can do the reduction of capital in any manner. Of course, that is subject to the confirmation of tribunal, but can do the reduction of capital in any manner. And then a particular list has been provided, the kind of reduction which can be done. And I feel so that that list is suggestive in nature. So the phrase which has been used under section 66, that is in any manner, is creating an ample doubt in the mind of the professionals whether selective reduction is possible or not. So the first school of thought that comes to the mind of the professional is that though the legislature is using the phrase in any manner, it does not contemplate that the company can be unreasonable and coercive, and therefore to avoid such unfairness, the company shall provide the opportunity of exit to all the shareholders in a proportionate manner, and it cannot go for selective reduction of capital. While the second school of thought in the mind of the professional says that the legislature itself is empowering the company to do the reduction of capital in any manner. And it is not only the board which is allowing this reduction of capital, but also the shareholders are allowing by way of a special resolution, and then it will be subject to the confirmation of the Honorable NCLT. And therefore the reduction of capital can be done by giving an exit opportunity to the selective group of persons. So the judgment which has created a doubt in my which has created an importance to place this question of law today, in that matter, the Honorable NCLT has allowed the scheme for reduction of capital wherein the opportunity to selective group of shareholders has been provided, though they were challenging, which has been later on appealed before the Honorable NCLT, and Honorable NCLT has also seconded the thought of Honorable NCLT and has not set aside the Honorable NCLT and rather allowed the reduction of capital. The major finding of that particular case of Honorable NCLT LAT is that the reduction of capital is a domestic concern of the company, and the role of the honorable court or tribunal is to the limited extent. If the requisite majority specified under the provisions is allowing the scheme, then the court is nowhere empowered to stop or refrain or set aside that particular scheme or do not allow the application. The court has to see only certain things. First, whether the articles is providing the power to the company to do the reduction. Second, whether the compliance under section 66 has been done or not. And at the third, whether the court is satisfied that the consideration provided to the shareholders who has been given the option to exit is fair or not. So, at the first instance, the selective reduction of capital is clearly possible. Now, coming to the second ground of contention, that is, valuation is unfair. The court has said that the valuation is a very subjective matter, and different valuers will be having different pattern of working, and therefore the value of share may vary person to person. Therefore, until or unless there is a grave negligence in the valuation which is apparently clear to be traced, the ground of valuation of unfair valuation is not tenable in case of reduction of capital. With this, we can conclude that the selective reduction of capital is quite possible. Thank you so much for listening. Now you will be able to see the list of judgments on which the Honorable NCLAT has relied upon before passing this particular judgment. And the NCLAT judgment which I was referring will be highlighted in blue. Thank you so much. Stay tuned. Thank you.